next, Jimmy, I would like for us to talk a little bit about loss carryforwards.
Okay.
That's been a big issue in my father's life, and other people that we know have had big issues and lost carryforwards. And it could be one of the most complex issues for family lawyers to deal with because of the contingent nature of the line item. All right.
Mhm.
So, can you tell us what a loss carryforward is?
A loss carry forward, and there are multiple components of it, but it's essentially a fully allowable, meaning it's a valid deduction of some kind that is currently not deductible, that is carry forward to future years. And it doesn't mean that there was a mistake in the current year. It means that the law limits that loss or that deduction or that credit because of the intentions of Congress or the regulations of the Internal Revenue Service, so that you can't take it all this year. And this is something that I see with family lawyers that unfortunately is missed many times. And this is an asset because just let me give you an over-the-top example to illustrate this. Let's say there is a loss of $10 million that's not allowed on the current year tax return, but it is allowable for future years. And if they're in a 40% tax bracket, let's say 50%, if they're in New York, California, or other high tax states, this $10 million loss carry forward is worth $5 million. This is a marital asset that should be on the marital balance sheet. But since it is not something that's titled, it's not something that you own, you drive, you sleep in, or you have a trading portfolio, is I would say more often than not listed as an asset. And I hate to put motives in the opposing counsel's reason for not listing it, but I think it may be on purpose because the data is in the tax return for the opposing side to see. But I typically see that many attorneys do not either have their own ability to do this, or they don't engage appropriate tax counsel or CPA to assist them with this, and they totally miss it because they're so focused on the house, the stock portfolio, the 401k, deferred compensation, that what's really just gold sitting on their tax return, they miss. And I, whenever I'm engaged to consult with attorneys on these type of things, I can usually pick this up in about a minute and a half, and because I know what I'm looking for, and it's like free money. And then when you bring this up to the opposing side, they'll say, "Well, that's not an asset. I can't spend money on that. I can't borrow against it." Well, that's just not true. And it's as much of an asset as stocks and bonds and money in the bank because it is money in the bank. And so it is probably the largest item that I see family law attorneys miss.
So, give it from a time value of money, net present value basis, and let's ignore discussion of a discount rate, that sort of thing. Uh, how many years are we talking about that could be a loss carry forward or series of losses carried forward into the future?
Well, these losses essentially, in most cases, last indefinitely. So if someone has a $10 million loss carry forward, it may have a 15-year expiration date, but typically it's unlimited. And so if let's just say that I am the party that is generating this loss from whatever it is, and I'm getting divorced, that's a valuable asset to me for the future. And if it just happens to never show up on the marital balance sheet, it's not split with the opposing spouse. I have not, you know, violated any rules. I've disclosed everything. The tax return's right there. The opposing side missed it completely. And let's just say that the year after one is divorced, and this example, my example with using this as an illustration, I generate a $10 million sale of my business the year after the divorce. I have just made that $10 million sale of my business tax free with a $10 million loss carry forward. I have saved $5 million in this example in taxes. And the former spouse says, wow, this is wrong. I should have benefited from this. Well, there was disclosure of this quote asset. Opposing counsel missed it, completely missed it. So there is no, in my opinion, and I'll let the attorneys decide this, there's no reason to, have the settlement set aside because it was not hidden. It was not hidden assets. It was just something that was staring at someone right in their face, and they failed to see it. This happens more often than one would like to think. Anyone that's involved, particularly that has businesses, they probably are going to have some sort of loss carry forward.
Great to know. Now, I know this is a very large topic, very broad. I'm going to ask a ridiculous question, but if you're going to pick out a rule or two that family lawyers should know about loss carry forwards in terms of their limitations from the CPA's perspective, what should lawyers know? And when they hear this issue with the CPA, know that they have to go to an independent CPA, not the spouse's current tax attorney. So they need to get somebody like yourself to help advise them.
Well, the things the attorney should be looking for, and these are so common that I would have it on, if I was the attorney, a checklist of things I'm specifically asking about. And I can go into more details about what each of these are. The first are net operating business losses, and they will simply be on an attached schedule, not a form within the tax returns. So I can't send you to an exact form because it's not, it's just a supporting schedule. Secondly, if there's particularly if they have rental real estate involved, there is a tax form for this called Form 8582 for passive loss activities that have carryovers. Thirdly, if someone has made significant charitable contributions and that's not allowed to be taken in particular year, you would have a very large deduction for charitable. And number four, if you have tax credits, for example, if you have invested in various solar activities or historic buildings or anything that's favored by the government at present, you likely are going to have tax credits that carry forward essentially indefinitely. And so those are the four that I would be looking for specifically. And anyone who is reasonably proficient in seeing these would be able to pick this out quickly. And so when I'm consulted by attorneys, and I've spoken to Miles many times about this, and I'm looking at something that he may want me to advise on, it's a very quick analysis to see if this is something that is there, and you will become a hero, frankly, with your client for discovering something that they likely did not even know existed. If you're representing the party that is generating these losses, that's the business person, they know about it. I can assure you that because they know what, their assets. But if you're representing the opposing side who may not be as involved in the businesses, they might not even understand this at all. And you all of a sudden find literally millions of dollars of quote hidden assets. And I don't mean to say that they're doing it inappropriately, but nobody's paying attention. It's a good way to make your client very, very, very happy with you.
That's a perfect answer and great segue into my next question. You've already talked about an example of loss carry forwards. What I'd like for you to do is give us another example of a loss carry forward, but how that value could be negotiated within a divorce if both spouses have knowledge of the loss carry forward, and one of the parties is saying, well, the loss carry forward could last way past my client's lifetime, and they may never be able to take advantage of it. So it's speculative, Mr. Luke.
Sure. Well, first of all, you would have to determine who does the tax loss belong to. And it could belong to either of the spouses, not necessarily jointly. The Internal Revenue Service is clear that if one of the spouses, their business activity generated this loss, then they are the one that can take it. And it's not tradable, like a dependent child exemption that could be allowed to either one, depending on the agreement of the former spouses. This might be specific to one spouse. They are the only person who could take this. So to them, it is a valuable asset. To the other spouse, it is an asset, the loss, that is worth nothing. So to the spouse that can use it, they then, just like if you're trading child exemptions on a tax return, should be and would be willing to trade cash on the marital balance sheet to the spouse that could not use that at some discounted rate, depending on what the future would hold. And the spouse who doesn't use it would have a windfall of cash at closing. But if to address your question of this might be speculative, it might never be generated. Yes, that's possible, but highly unlikely. Let me illustrate. Let's just say I have a $2 million loss carry forward, and I'm nearing the end of my life. And so I might die before I can use that loss. But let's just say I have a $2 million IRA account or 401k account. Before I die, I could make a withdrawal of $2 million from my IRA, generate $2 million of income. Now I have a $2 million loss carry forward. It's now completely tax-free. So very, very rarely would it be reasonable to say that that future loss is speculative and not included in the marital balance sheet, because clients of some wealth and with some discretion as to how to organize their assets and when they generate income can make that loss go away by generating income. Like I spoke of regarding many of my clients, they choose to pay tax. They don't pay tax. Properly planned, the tax doesn't just happen. We're planning for multiple years in advance. And for example, like right now, we're talking about capital gains. The Biden administration is proposing, and if they're elected and there's a Democratic House and Senate, are proposing to remove the reduced tax benefits of long-term capital gains. And so immediately capital gains, long-term capital gains would go from a 20% rate to an upper 30s rate, doubling the tax. So depending on what one's thoughts are about what is the likely outcome of the election in November of 2024, I have clients right now who are planning on generating capital gains in 24 to pay tax at the 20% rate, versus if the Biden administration's proposal is enacted and they generated this same gain in 25 and pay double the tax. So with good planning, and good planning is not limited to 1 year, it's led to a multiple year scenario. It actually can be something in a marital law situation that benefits both spouses. It does not have to be a win for one, a lose for the other. When properly structured, you would have these losses to be attributed to the spouse that could benefit from them the most, very similar to the of who gets to claim the child on the return. That would be structured so that which spouse would receive the most benefit from it, so that even though the two people are no longer together in a marriage, if they can cooperate, and it's which is easier said than done, But if they can cooperate, the formerly married couple, the family unit, could significantly save money on taxes. But we all do know that some spouses have trouble getting along. I don't know why that is, but it seems to be that way.